Not just cemented together. Okay, okay.
Morning.
Testing, testing. Let's bring the meeting to order, please.
Okay.
Debbie, if we could have a roll call, please.
Chairman Vincent,
Here.
Carolyn Gallagher. Here. Bob Thinis.
Here.
Rex Sims. Here. Don Colapetro.
Here.
Henry Bird.
Here.
Fred Forbes.
Excused. Okay, if we could, let's have a discussion of the ordinances.
Thank you. We have the following ordinances that are to be reviewed by the local planning agency for consistency with the comprehensive plan. That is a requirement of adoption of land development regulations. The first is an ordinance of the City of Bonita Springs pertaining to the density reduction groundwater resource area designated on the City of Bonita Springs future land use map, establishing a moratorium on the processing of any comprehensive plan amendments within the density reduction groundwater resource future land use category located in the eastern portion of the City of Bonita Springs, east of I-75, and north of Bonita Beach Road, providing for legislative findings. Purpose, establishing a specific plan for the density reduction groundwater resource area that balances the interest of development, conservation, and resource protection, declaring a temporary moratorium, providing for severability and an effective date. I first want to point out, I need to apologize. When we got the packet ready, packet preparation preceded the time of when I made the changes that council asked. So I would ask that you use the draft that says dated November 19th, 2013, revised December 5th, 2013. If you use the older draft, you will not see what I made changes that council asked me to make, and that would be very embarrassing.
Okay.
The second thing is I am grateful at this moment for an excused absence by Mr. Forbes. In the future, we will try to do some kind of advertisement so members of the Water Strategy Task Force can speak. But because he's also on the Water Strategy Task Force, I was presented with a dilemma this morning that fortunately was resolved by his not being here. This will go to City Council at their final hearing on December 18th. The changes are in Section 2, and the changes in this case are marked by underlines and crosshatches. We changed the purpose of the moratorium. We made it very clear that this moratorium will remain in effect until January 16, 2015, unless City Council adopts ordinances, which would require 2 public hearings and a 30-day effective date, so it would take at least 60 to 70 days to ever get rid of this moratorium. So my guess is the moratorium will just stay during the time. But, I mean, that's up to council. But it will require an ordinance if we were to reduce the time period, as well as to extend it. And then 4C was taken out of the equation at the request of City Council. At this time, you can have public comment, and this is a moratorium. If you have questions as to moratorium, I'll be happy to answer them.
Mr. Chairman?
Yes.
I have I guess my questions are the same even with the changes, but on page 1, and I thought we discussed this at length before, but in the third paragraph down, where it's limiting land use purposes to conservation, agricultural, recreational uses at a maximum, and public schools. You put a public school out there and you've got dozens and dozens of buses and cars and runoff. I think that's the wrong place for a public school, is in what's proposed to be the DRGR.
I was taking the language that is in the DRGR comprehensive plan. I am not disagreeing or agreeing with you either way. We had there was infinite discussions on some of this issue.
And it's going to stay there.
It's going to stay until council tells me how to change it.
Okay. Well,
Tell
that's
staff how to change it.
for as humble it is, that's my opinion. I mean, I look at the charter schools, and you've got not only the buses, but you've got hundreds of cars lined up idling, and you can just imagine, you know, a drop here and a drop there, and you just multiply that, and there's your runoff. But, okay, that's
Well,
my
it's
piece
just-
on that.
It's the same as agricultural and issues if you don't follow best management practice. Obviously, best management practices is a different situation. Residential, when you have such a low a low density, you're not going to have sewer lines, and without sewer lines, you're going to have septic tanks, and septic tanks have their other, issues into, and that is one of the biggest problems we have in the Imperial River. Council, the moratorium does allow, like, if somebody wants a new residence, if somebody wants a school, if somebody wants a agricultural, he has to give the permit. It doesn't affect rezonings or permit applications. It only affects processing of comprehensive plan applications.
Just the fact that it's allowed. But anyway, I have, the only other thing I have on this, I have a couple of small typos.
Oh.
On 2 of 6, 1, 2, 3, paragraph 4, Bonita Springs City Council desires to enact, that should be a small a.
Yes, thank you.
And on 4 of 6, on B, I believe that should be a period after area.
Oh, now it is, you're right.
And C, I think we're missing 1 comma.
But C's deleted.
Oh, okay, I'm sorry, I missed that one coming out. That wasn't, we didn't get a new page of that, did we?
The revised December 5th should have C as a
Okay,
deletion.
all right.
Which is why you gave it a period here. Oh, I thought that's why it's, okay.
I think that was it.
Okay, further
Can
comment?
I say something about his schools?
Yes.
When I was out in the DRGR area, I noticed that there is some land with a big sign that says it's for future public schools. Does anybody know what I'm talking about?
Probably the land owned by the school district.
Yes.
Okay, my question is it dangerous to have the public schools right next to all of those satellite dishes that Comcast has out there? They have 20 or 40, a lot of satellite dishes.
That's going to be more of a decision for the school board because they have their own permitting process that does not involve the city.
Right, it would be the same issues as like, right.
Cell phone towers and stuff,
I was
maybe?
thinking more of the telephone lines, the big, and the electric lines, the big power lines, where you might have a school near power lines and people have questions, electromagnetic.
Does anybody know if those satellite dishes are dangerous to be around schools or areas that are
I can tell you I'm
Congested?
preempted that it's an issue that FCC, I think it's FCC, has concerns. I can check FCC Gov, but
I think most of those are reception dishes. I don't
Yeah,
think
I
there's
don't
any
think they're
transmission
satellite.
involved.
well, they have to transmit somehow
They transmit by cable from there.
from there. by
right,
cable.
that's their,
Okay.
that's
Right.
their big,
I-
I've toured the facility a long time ago. I mean, that's.
Pretty complex.
Yeah.
I do know that the transmission are the most dangerous, not the receivers.
I think they're only receiving,
Okay.
and I don't think that, I mean, because.
Not positive, but that's what they appear to be. That's why they're so huge.
I thought they were probably both.
No, I mean, I know that they have the boxes and all the cable out there, the machinery. I've seen that. I've been
Okay.
inside.
Okay,
Just curious question.
okay.
Thank you.
Rex?
I have a couple of questions, issues, I guess. And the first one is kind of a basic reason that we're here today, because essentially, it appears to me that our duty here as this committee is to determine whether or not there's any conflict with the comprehensive plan with this ordinance. And we went through this very extensively a short time back on the homeless shelter about the moratorium issue with this board. And at that hearing, we determined that the moratorium was not a issue with the comp plan, and that this board really didn't take a position on it. Now, my question comes up is the same argument that was issued back then. While the moratorium is an option that the city council has to do, it really is not involved in our comp plan. There's no mention of moratorium in the comp plan anyplace. So I'm wondering if, first off, if they're asking us for something that we really don't have the ability or authority to grant, is the first thing. The second question, and that's a basic thing, and I think we discussed it at great length in the homeless shelter issue. And And this board came up with an answer at that time that it was not pertinent to the comp plan. But the thing I'm looking at here, I'll go to item 2. In the temporary moratorium program here on page 3, down in the middle we have under D, no applications may be processed, even those that have been submitted prior. Nothing can be processed, and I can understand that. That's the purpose of the moratorium. But I also look at a issue. One of the reasons we incorporated Bonita Springs is there was a issue out in the DRGR of a place called Jones Trailer Park. I don't know if anybody's here long enough to remember it, but it was a third world settlement. And one of the things that we promised when we incorporated the city that we would, that would go away. We worked very hard here at this committee to get a development in that of 120 units, as I recall, in that site. And I thought it was a wonderful contribution to that site, would do away with a 30-year-old sewage plant that never had any maintenance and a lot of other bad things. And I was very happy to see that happen. The developer even doubled his road fees and so forth. It was a good deal for the city all the way around. Well, I don't know what the status of it is now. It's probably in bank sale or something. I don't know. But the point is it's there. And it was put there through the legal process. So I look at it and say, could we arbitrarily say right now during this moratorium that something that was issued previously would now be void?
No, as far as Jones Trailer Park, and same thing, that's a good question, because also the YMCA, we recently took it out of the DRGR and changed it to community facilities
Yes.
type. I have to look at him sometimes for the factual information. So those two are out of the DRGR. The moratorium does not apply to those two parcels. They were
Okay.
removed from the moratorium ahead of time. Now, I just want to raise the point, there's a distinction between the homeless shelter moratorium and this particular moratorium, in that this one is actually a comprehensive plan, which I wrote a memo as to my opinion on that, but be it as it may, for city council, in this situation, we do have to follow, there's case law called Sandoval versus Buntrock that says if you're going to create any kind of land development moratorium, you need to take it to, it needs to have the same formality as you would any land use ordinance. And in that case, I have to take it to the LPA for a review with consistency. Whether you feel that it's yours or not, it's jurisdictionally, you do need to review it. So, I mean,
Okay, now my third issue, and I thank you, I understand what you're saying there. My third issue here is, on that page, is item G. And it says, in essence, that anything that complies with the existing zoning there, one building every so many acres, is not affected by this moratorium.
Correct.
And I'm having a little difficulty with that, because if we are establishing a moratorium on things that are zoned by right, how can we say, well, that won't fly, but this will?
Because it's addressing amendments to the comprehensive plan and not to a particular property zoning. So what this says is if your future land use designation is density reduction groundwater recharge, you are prohibited from filing an application to amend that to a different district for a period of 1 year. If, however, what you want to do is consistent with that designation, but you need to amend or alter your zoning, you are allowed to do that during that period, but you are not allowed to do anything that would affect the future land use designation.
So you could not expand on any situation there, is what you're saying.
That's not true. You would be able to, but you would be able to do it from a zoning perspective.
Okay.
And you would be able to do it from a building perspective, meaning you can
Right.
get building permits and you can file rezoning applications. But both those, not just both, but any type of permit that could be filed must be consistent with the DRGR future land use designation during the period of the moratorium.
I'll give an example. Let's say you're doing farming, and in this particular case, the Right to Farm Act doesn't apply, because a lot of times he can't do permitting anyway with farming because of the Right to Farm Act. But they need to get some kind of permits or some kind of modifications in there. Maybe it's some kind of agricultural that you do need special exception, because there's a few egregious, I think, fish ponds. There's a few things that could be a little egregious that I think do qualify for, I'm looking at him.
Yeah,
All right.
that might not be the.
Well, but let me try to give the analogy. If somebody has to come in and actually apply for plumbing or for some kind of permit that is required and it's permissible in the DRGR, let's say a house, the residential house, and staff would be issuing that residential house permit. Staff would be issuing whatever it needs for a septic tank, for the driveway. All of those type of permitting can still go through. We're not going to cause any headaches to people, status quo in their normal lifestyle. The only change is if they wanted to change that portion of the city to a different comprehensive plan classification, they cannot.
That's my question.
Okay. Bob?
Yeah, I wanted to clarify something along the line of Rex's comments. Let me make this clear. In this ordinance, what we're saying is you can submit an application, but it cannot be processed, right? Because I don't think it's legal for you to tell someone he can't submit an application.
Correct.
And so what we're doing here is we're just restricting staff's ability to process it, right?
Correct.
That's correct.
Okay.
And the minimum acreage now is what, 10 acres?
There is some lots of record that are smaller than 10.
If you're looking at the minimum density, it is 1 per 10 acres. There are lots out there that are smaller, and there are wetlands out there where the density is 1 unit per 20 acres. So, but minimum residential density on upland areas is 1 per 10.
I had some questions and comments on some things that didn't seem consistent within the writing of the ordinance. First of all, well, they have to do with timing. When we look at the, first of all, if you look at the homeless shelter ordinance, right in the first paragraph, it states out the time, it puts in a year. This one just said, I think
Time period of 12 months beginning January 17, 2014. And that's because that's the actual date that the
well,
moratorium can
this
go
in the
into
first
effect.
paragraph says a temporary moratorium period and doesn't really say any time frame. That's in that first paragraph of the ordinance itself. Then later on, at another place, it says a reasonable amount of time, and another place, it says a year. So that's one of my inconsistencies, and maybe it's really not an inconsistency, I don't know. The other thing has to,
Are you talking about the title block?
talking about the title block versus
Okay, once-
Section 2 purpose.
Understand, once and I explained it to council,
And
once
maybe-
I prepare a title block, I cannot change it unless you want this moratorium to take another 2 months.
Okay.
So that's not changeable, that's
Okay.
not negotiable.
Okay, all right, and maybe it doesn't mean anything. I was just looking at the homeless
And that was
ordinance, and
right.
it actually spelled out a year, 12 months, whatever.
Right.
So, okay, so that doesn't matter. The other thing has to do, and I hope I can make this clear what I'm thinking, is that this ordinance is for 12 months, and this ordinance talks about really putting the whole picture together. It also talks about the task force, but the task force is only given 12 months, and the difference is about a month. The task force ends in December, and the other one ends in the January following. The task force is tasked with only water issues. So they're not looking at development other than water issue related development. They're not looking at, what's happening to populations in different places that would affect our development. It's not looking at
Transportation
how we would do,
issues,
like
right.
this chamber said, how we would do a holistic look at that area if we wanted to develop it and not piecemeal it. So it's not looking at those things. So this ordinance does imply that we're going to come out with a plan at the end. I'm trying to take.
Right.
So my question is, we don't have enough time to do the water task force, have it end, and then we've got a month to kind of come out during this moratorium to finish everything
Sure.
else?
Let me first of all explain. I cannot do a moratorium over a year without it being a taking.
Being a what?
Taking, where it's compensatory taking.
Ah, okay.
So I have a time frame based on state law and federal law that limits how much time city council can use. Now, they can extend if they're acting in good faith. This issue was brought up to city council, and the city manager did address it, that will be handled by staff or other committees as far as transportation, other concerns that are out there. Because I know water is a major concern. I don't want to displace that, but I think there's other issues as, to have that fit in within the city to be compatible that go well beyond the water and environmental issues. So the city manager is working at that level, is working on those issues in addition to this committee working. So will things be able to be fit into place and that puzzle work? I don't know. I can only, provide the basic starting point of the moratorium. Now, the moratorium does not go into effect because the ordinance takes 30 days effective date. Does not go into effect until January
Yeah, that was my
17th.
other question you're getting to.
Because of the fact that the city charter does not allow the ordinance effective date for 30 days following its adoption at city council, I have to wait the extra 30 days. So,
Is that giving a window of opportunity to anybody to come in and,
they can turn in applications, but they won't be processed, and it's expensive to turn in applications. It's not an easy, submittal process to say.
been done?
Well, it's not and you remember them saying it's not easy, it's not cheap. I think there's the Smith v. Clearwater case where people say, well, this is definitely, people are on notice, we're doing this. So if they're not, shame on them. And
Okay.
again, this is interesting because it's legislative in nature as opposed to something where the city has a burden to actually process. This is something where, as long as reasonable men can disagree, they never have to change the DRGR area. It can always remain DRGR if that is the legislative determination of the body, of the elected people. That's why I felt the moratorium was silly, but they said we want a moratorium anyway, and so
No.
hence I drafted a moratorium.
Okay, I think I understand what you're saying. I think that I do agree. Now, I'm wondering also, what if the city is going to be working with all of these other issues that go hand in hand with the DRGR and possible development there? Is there going to be any coordination with the task force, the water task force?
Well,
So they can sort of figure out where they're going along the line?
It's not necessarily going, I don't know what the relationship will be, meaning I don't know if we're going to be bringing people in to discuss or present to the water task force, but the work that comes out of the water task force needs to be consistent with other areas that we're addressing. So you cannot have one area going one direction and another.
How are you going to know that unless you're coordinating?
Well, we're going to be at both, so.
and let me also point out, based on state statute and city ordinance, the local planning agency has jurisdiction of the comprehensive plan. So ultimately, they're going to make recommendations. It's up to you to do some, I would believe that you would be the body that would review it before city council would review it. This is a little backwards approach in having, council's relationship with the water strategy task force, but yet you have a relationship, and I brought that issue up to council, and I did not feel I got exactly a answer if I had to draw this on a chart showing, if anyone ever goes up to my office, you'll always see there's lots of different keys and charts and diagrams, and I have a great one of the comprehensive planning process. This one, and it has the LPA and has the city council, then it has DEO and other agencies, for your basic comprehensive plan process. It, of course, doesn't have a water strategy task force, but the basic state of Florida flow chart for it, you guys will be at that other end. And then the other thing which I pointed out to people when I look at that chart is once you're ready for public hearings. There's a lot of stuff prior to public hearing level, and here we're not going to be processing anything. So I've seen comprehensive plan amendments take 3 to 5 years before it made it to a public hearing level. The one that was turned in prior to this comprehensive plan amendment was turned in over a year ago. The key was we were going to do a development agreement and have that reviewed, and city council, that requires 2 public hearings before city council and a full month of advertisements prior to doing it if you follow the statute, which you have to. That would have taken another couple months or 6 months minimum. The only one we've ever been able to process faster than that was the racetrack one, or if it was just a very simple, developer contribution.
Ms. Gallagher, this task force does create a unique situation. There is no template for it. We are basically creating these things as we go. However, I can tell you that this is not the first time we've done something unique, and we just work with the system to make sure that everybody stays on the same page. Really, it's just a matter of communication.
And process is messy. This is going to, obviously, we experienced, because I added to the green sheet one letter from an applicant who is in the pipeline. I had council members upset, and I had citizens upset just because, and I have an ethical obligation as a lawyer that if somebody, brings something forward, I'm to bring it to the client. And the only way I can bring it to a client sometimes is by bringing it to the client in front of, so they can discuss it as a group. That's an example of, trying to follow a process and people getting very upset by just following a process. So it will be messy, this next year, but you guys have been through that. And this time they took the messy part away from you guys as opposed to, or the beginning messy part away from y'all, as opposed to the homeless shelter where they said, you guys go and figure it out. So.
Let me ask a question, and I think, John, this might be directed to you. Considering the moratorium, what are the safeguards here for the development of that area that is reviewed by you? Let's suppose that the moratorium does not take place. What are the safeguards in that area?
To amend the future land use map requires an application, requires a hearing before this agency, then requires ultimately 3 hearings in front of the city council. So there is an extensive process. In terms of the safeguards, meeting other standards of your comprehensive plan are really the strongest set of standards you have. How are you going to address transportation issues? How are you going to address utilities? Those issues have been a stumbling block for most ideas that have happened out there in the past. There could be someone that decides that it is worth running utility lines however many miles to their property and to pay for additional improvements that would be necessary to the transportation network as part of their development. But those type of applications and developers are very few and far between. So its remote nature from a concurrency standpoint is the greatest protection.
Yes, that answers my question, because without the moratorium, we still have quite a few safeguards here against the development or overdevelopment of the DRGR. And so that's our question today, is whether or not we agree with this ordinance for having the moratorium, and whether or not we think, I guess, here that it would be important to have or not to have, and to be assured that there are protections for overpopulation or what have you, to not only the DRGR, but, the density reduction has to do with growth and what this does to growth for the community. And I don't think at this point Bonita Springs has decided how big we should be. So it's kind of a moot point as to whether we should go in there or not, but it depends on who is directing the growth of the city and why we should or should not be in there. So whether or not a moratorium helps in that respect, I don't know. Water is one issue, but just simple growth and the usurping of land, valuable land, is another. I mean, those are my comments here, so that's what we have to decide today, is whether or not we're going to agree with this ordinance.
Well, any outcome of the study that is made, just in the water issue, is then going to have to result in ordinances or change in the comp plan, which is an extended, lengthy process. So I don't see this as anything happening here for an extended period of time. I don't know if some of the people here on the board may not remember, but 8 years ago, this board spent about a year and a half dealing with the DRGR and the 3 water surveys that experts presented to us at great length, and that all conflicted with one another. So it's an issue that is more than just superficial thing, and while this moratorium may solve the immediate, it's only the beginning.
But in resolving the water issue, quality of the water issue leads to whether or not there is a run on land. Because if the report turns up as being it's no impact whatsoever on the water quality out there, then the next thing that will happen is growth.
Not necessarily. There's other confining situations. We're looking at the groundwater resource issue, but you also need to look at the density reduction, which makes sense in a county, does not necessarily make sense in a city, but there might be tools that we need to look at as we look at the growth, because that, from a land mass, and I'm sorry if I'm staring out into space, I'm actually looking at the map. When you realize how big it is, you're looking at 25% of the land mass of the city. I mean, that is a large area of land that it's kind of a new rural initiatives, regional. I mean, there's a lot of cities that are smaller than the DRGR area in itself. So, trying to make sure that we get transportation issues resolved. You want to have it so your trip generation, so most people are not having to drive to another part of the city to get services, if they're able to get things accommodated in that area. Getting it to have whatever characteristic or plan, similar to the branding of the Old 41 area, how the people on Hickory Island see themselves. That area will probably need its own, the East Bonita folks, that area will have its own type of brand also. So there's a lot of planning that is needed in that area before the land grab starts.
That's kind of a point, and that's a good term, land grab, because once the objection to why you should grow in that area is resolved to the benefit of growth, then growth happens. And no matter how much you want to control it from a comp plan standpoint, right now it's 1 per 10. We are increasing, say, the downtown area 1 to 15, 15 housing units now. So things tend to expand.
15 to an acre as opposed to here's one unit per 10 acres.
Right. So yes, there's a lot of land mass, but I guess the question's not being answered to me is how big do we want to be? How big do we have to be? And what you're losing that you can't make any more of is land.
Right, and there's a lot of soul searching that goes above just the environmental issues.
Yes.
I mean, obviously the environmental issues are critical. I don't want anyone to think I'm neglecting them, but there's a lot of other issues in that particular area that you also need to look at.
Yes, so that's kind of the questions being asked of us this morning, is to take a look at that and decide here whether or not we recommend to the council that we want to move forward with, hey, let's do another study.
And here we've had a study. There is a study out there. This is now the citizens exploring the study, discussing with some of the other people that have been out there, because we know, like, not Dr. Beaver, Dr. Beaver's the wife. Jim Beaver did a wonderful presentation. He is a doctor? I don't think, okay. He did a wonderful I don't think so. He did a wonderful presentation on, different kind of computer modeling of different types of elements of what you can put in to create different things. Eric Livingston gave some great information. And the one thing that no matter what the different people who spoke, Roger Kopp also spoke, no matter who spoke and no matter which and we've hired consultants, they've all said the same thing, which is that area is in need of planning. Right now, the only plan that is called for it is the third whereas clause in the paragraph. And it's clearly, I think LPA recognizes that's not sufficient. The question is what should it be? And that's a much harder question to answer.
I guess my question would be, why does it need planning?
Well,
well,
if you look
That makes an assumption that
Mr.
needs to be
Houston.
used.
Yeah.
the bottom line to this is, by the time the city incorporated, much of the area within that boundary was already developed in some form or fashion. Thank you for interrupting. And from that time, you really have one area in which the city will plan on its own. It will be entirely done by the city of Bonita Springs, and that is the DRGR. Now, what you do out there is a policy decision, whether you want to develop or
Right.
you don't want to develop, and that is up to the city council. My main concern is how we do that. And so my main role through this process, moratorium, no moratorium, development or no development, is to make sure that whatever goes in out there is functional and actually improves our current situation, because that area has a lot of needs. And we've discussed some of them, but we have definitely not discussed the entire list that needs to be included. So when we're looking at this, Audrey's right. There's really only one section of this that discusses the planning out there. But I believe that once the direction is set by the city council as to what they want to see, how big do they want to be, that's when the real work starts. So
I think you answered my question, why it needs to be planned, and that's because there can be growth out there.
Mm-hmm.
That's why. Is what we have enough with one per 10 acres, or do we need something else? And that's,
Are you ready for?
yeah.
Mr. Chairman, under the purpose down here, the purpose is to balance the interests of all these different groups. I'm not sure that will really happen in the real world, but I think this is probably the first step that we need to take to enable the city council to start that planning process.
Now remember, the purpose has changed of the moratorium.
Yeah. And so I would make a motion that we find this acceptable to this board.
Second.
That's finding of consistency?
Beg your pardon?
Yes.
Okay.
Accepted. Motion to
Second
accept.
over there.
Second. Yep.
Second. Okay. Motion passed.
Okay, and I'll make the changes from Mr. Colapietro. Thank you very much. The next,
Miss me?
I do. Yeah, absolutely. The next ordinance is a tiny one. This is of the City of Bonita Springs relating to building and construction codes, identifying work not requiring a permit, providing for conflict, severability, codification, inclusion in codes, Scrivener's errors, and effective date. This goes for the second final reading on December 18th. The LPA did review this ordinance at their November meeting, so I do have a motion that it is consistent. Just as an update, the ordinance was revised. I think it's actually stapled to your moratorium. Maybe, maybe not.
I don't see any revisions to it.
Yeah, I've got it.
I'm sorry, yes, and it was revised December 5th. The revision was to add the water heater language that's underlined on page 2 of 3, showing replacement of water heaters when it does not generate a technology change. Any change in technology will require a permit. For example, a tank system to a tankless water heater system would require a permit. This was against the advice of the building official, but that's city council's call.
Mr. Chairman, we discussed this at great length of time before, and the only thing, I'm in favor of it, but the only thing that have raised the issue again is on page 2 about the temporary buildings. I'm not sure that we ought to be encouraging this. And so my question is, could a temporary building or one of those canvas garages, when they don't need a permit to do it, but could there be some kind of time limit put on this where they could have this thing for 24 months or something, so that it would be it wouldn't become a permanent fixture?
I think to address that, and there is a concern with your issue, is that we not necessarily look at a building permit for those type of structures, but we look at maybe zoning regulations that would address
Okay.
their length of stay or their location.
You looking at car cover? Rick?
Yes.
Is that okay? Yeah.
And I see in here where one of the materials is metal for that car cover. A car cover being different from a carport
Well, they're talking about the frame.
frame.
Right, right.
Wood,
It
metal, or
cannot have
plastic frame.
electrical or plumbing, so I would imagine a carport would probably have electrical, like a
Yeah.
light,
Okay.
or porte cochere.
Any comments,
Um,
Ruther?
I just have, I got a couple questions on page 1. Second, whereas, I'm not sure it's the way, if it reads right, but it's the building official can determine whether certain work or improvements would need a building permit. I'm not sure. It read strange. And then the 1/3,
Doesn't matter.
the building official has determined that the work identified in this section says do not, it should,
Yeah, it should be
does.
does not.
Okay,
So much for my grammar today.
okay.
I miss you.
Any other questions?
About the car covers, it seems to me that limiting the time that they would be there, really has no bearing. If you have a proliferation of them and people need them, allowing them to have them for a year or two doesn't really solve their problem, because if they're a permanent resident, they're going to need a car cover. Obviously, they have a car cover because they can't have a garage. So, I mean,
Or can't afford one.
or can't afford one, or can't be zoned on their property. It's too close to lines, to sidelines. So I'm seeing, I don't even know how to express this. If they put up one of these car covers, I mean, it's kind of futile for them to even have it, because they're going to have to get rid of it, even though their need will continue. So why even allow it if we don't like them sprouting up all over the city? I'm not saying that my opinion is I'm not in favor of them. I really have not looked around at enough car covers to know what they look like. But it seems like limiting the time is not worth the effort.
And I would agree with that, and I think that what's before you is saying that it does not need a building permit. And I tend to agree with that because it's not really a structure. However, both Mr. Sims and yourself raised a very good question. Should it be there? How long should it be there? Where should it go? And those are going to be zoning questions. And I would think that if you wanted to, you could make as part of your recommendation to City Council that you either do or do not feel is consistent with the comprehensive plan. But in addition to that, you think this should be addressed in your zoning ordinance.
And I don't think zoning, I think property maintenance. I mean, the concern is something that you're worried that it's going to get in derelict situation. I mean, then it's not a zoning, it's a property maintenance.
There's both, I think.
Mr. Chairman, in my business, I get around town, all the streets, side streets, back alleys, and every place, and it's amazing, these canvas carports, plastic carports. We mention automobile here, or car, but actually they're used to cover up boats, they're used for workshops, they have a motorcycle stored in them. There's a varied use of them, and some of them have acquired over a period of time a semi-permanency. And some of them are just used like at Citrus Park during season, and I have no problem with that. But others I see are here with built-in workshops inside and lighting and so forth and so on. So it's an issue that someplace down the road needs to be addressed, and zoning is the way to do it.
Yeah, I agree. Zoning is the way to do it. John, right now, how is that? It just depends on the area, right? As to the zoning, the wording that's in the comp plan.
It tends to be in flux because really we're looking at kind of taking them out of building permits, and so what do we do with it then? And I think the city attorney's correct. The condition of these structures, lack of a better word, is a major concern as they become semi-permanent. You also have questions as to where they should go, how many you should be able to have. That would be a zoning question. So I think you have two sections of regulations that need to be addressed if you're going to allow these in any form.
Can we make a recommendation to the council here that's outside of this? That we want to limit these or
Well, maybe we need to.
But you'll remember to say it?
I'll say
As long as he remembers, that's my big concern. Is
One
there's
of
a
the
lot of work
issues
here.
that they had in Cape Coral a number of years ago was this very thing, which they were used for on top of boat lifts. They're used for boat covers, and when it first started out, it was kind of a good idea, and then these things grew into structures of some importance, and so that hasn't really happened here that I've seen so much, but it is an issue that is somehow is going to have to be addressed someplace.
Maybe we should address it as a condition of the structure rather, so it doesn't deteriorate. That might be what we look at rather than the time or whether it's there. First, we have to decide, should we allow them, or whoever, zoning, whatever. And second, if we allow them, then are we going to allow them to deteriorate? And what is the line?
they've been allowed so far.
They have.
What's been the reaction to that? Is it overwhelming that the neighborhood has a problem with it?
Just like anything else of this nature, there are areas and people that have done it very well, and there's no question or concern, and there are other people that have not done it well or allowed these covers to fall into disrepair. And while there are some standards within the current property maintenance code that allows code enforcement to address this, it's not as strong or as direct as it could be. And I think that if you start looking at it as a specific type of structure or facility, you're able to have more specific standards to address it.
But it's a use that is probably used in some areas of the cities more than others.
Yes, sir.
And the reason is what we've set up here about can't afford a carport or a garage, or et cetera. And so the question still remains, are you disallowing them for having any kind of a cover at all over the cars? If you do, then, it's a matter of maintenance of those things. So, I mean, if we say that no building permit is required, that means they can go up any place that meets the requirements. So I guess that's what we're charged with here, is whether or not we want to approve this as is. Do I have a motion? Any kind of a motion at all?
I'll make the motion to approve it.
Second?
Well, just one question. We're just going to approve or disapprove? Do we have any control over deteriorating structures?
That would come under property maintenance.
You do not have any direct control to make changes in this current regulations, but you could suggest that city council make those changes.
That'd be a code enforcement issue.
Yeah, and I don't think that it necessarily needs to be changed. I mean, this is whether or not to issue a building permit for a carport.
Right.
This is not whether or not, if something is in derelict situation, whether you give a permit or not, something can be derelict and something 6 months, 1 year, 5 years can look gorgeous.
We had a similar issue a few years ago where we had an ordinance to put up fencing around your property to hide the junk in the backyard and so forth. And many, many people did. I mean, there's fences went up all over Bonita Springs. Some of them are still maintained and look very nice today. Some of them look worse than the issue that we started with. And that develops into a code enforcement situation. The neighbor calls and code takes care of it. It's not really covered in this here.
So we do have the enforcement part of this to take care of the ones that are derelict.
You have what's in the existing property maintenance code, and like I said, I don't think it prohibits code enforcement from maintaining a standard. I don't know if that standard is going to be as direct or specific as they would like. It'd be a conversation we have to have with them to see if any other changes would be suggested on their part.
So the question still is, and we had a motion for it, that there would not be a building permit required for the issuance of, or the building of these structures. And we had a second, and if there's no other comments, it's passed.
I will also mention to the city council to take a look at the zoning regulations for these shelters and also the property maintenance code for.
Good. Thank you, Jim. Thank you.
The next
I'd like to have a vote on this, please.
Oh, no, you've already found it consistent with the
We
comprehensive
did.
plan.
But you don't need to vote on that?
I don't think I need a vote.
Okay.
The main thing I wanted was, because in the original green sheet, I talked about the public, that we'd have it at your meeting of December 12th. I wanted, if public wanted to, I didn't want some situation where public didn't feel that because I scheduled it faster, I didn't want a situation where
And
public.
we're leaving this as written, right? That's what we voted?
Yes, that's
Yeah.
right.
I agree.
Subject to a couple changes Mr. Colapietro gave me. The next ordinance is the Land Development Code amending and replacing Chapter 7 Environmental of the City of Bonita Springs Land Development Code, amending Sections 741 through 781 dock and shoreline structures, creating facility siting criteria, transfer of watercraft slip credits, and beach dune walkover provisions, amending 7111 through 7116, the marine sanitation, providing for conflicts of law, severability, codification, Scrivener's errors, inclusion in code, and an effective date. This ordinance will again be heard December 18th. You have reviewed the ordinance for consistency with the comprehensive plan and previously found it consistent with the comprehensive plan. I did receive in this situation a recent amendment that was requested by code enforcement, I should add, that Mike Kirby provided me by email. That has not been incorporated in section 7-73 of the ordinance, 773 or 775 of the ordinance at this point, but is actually marked and highlighted in the email that you have there dated December 10th. And that is to the section, I don't know what number it is right now, but, and it was just adding some additional language in there.
That probably addresses what's on page 14 of the original.
Yes.
There's a drawing there of the riprap.
Yes, that's the correct page, because if you look above the drawing, the changes are added to paragraph 2 on riprap revetment.
Right.
Thank you. So there's a few extra sentences there, which would be nice.
Any questions
Well,
for Maggie?
I just in general, if I may, Martha Simons brought up during the city council meeting that she was concerned about deteriorating docks.
Mhm.
So it would seem in some ways that it would be appropriate here. It's not addressed. Perhaps it's more appropriate in a code enforcement area. I don't know.
That's correct.
I just wanted to bring that up to start.
Yes, and council had
Thinking
extensive
process.
conversation about it and has asked code enforcement to take a look at the situation. It is a situation, but depending on where the dock is, there's a different situation, and the last thing the city wants to be in the situation is telling people they have to remove old pilings that you might see as a problem, but is the only way that people have their state submerged land lease protection. So it is more difficult of an issue, and it's not being added as a change to this document. It'd be easy to create a magic wand. It sounds easy to create a magic wand, but this is one where it is not easy.
Okay.
But I will say the state of Florida does enforce when they do see a derelict situation, because the city got pegged about 2 or 3 years ago for one of the docks we had at Bamboo Village that we had to, we were okay, we had to remove it as subject to our submerged land lease.
But freestanding piling is not an issue.
I'm saying that depending on what's out there and what is factually out there may make a difference in removal or treating of the derelict. Some people, like I said, some docks may have property maintenance issues and should address that. There might be some piling, or not pilings, but like decking missing or something. But code enforcement already has the ability to enforce that.
Mike Kirby, for the record. A freestanding piling is not really a life, health, safety issue, but a dock in disrepair where you can
Right.
walk out and fall through it, that's a little bit different. So there are some technicalities where you would.
Now, when docks, when you get a permit to demolish a dock or a boathouse or pier or whatever, piling removal is part of that requirement, right?
It depends. Sometimes if you're looking at a replacement or you're looking to preserve certain rights, they will leave those pilings in. If there is no intention to keep any current entitlements or rights and the property owner does not want a dock, it could be included as part of the removal.
So it's at your discretion to say, well, we want the piling out, or
To a certain extent, and it's also up to the property owner to determine if they want to remove those pilings.
Are you saying that it's a requirement to save the pilings if you want to save the rights to put a dock there at a later
If
date?
there are not plans to rebuild immediately or within 6 months or a year, there could be certain situations that would necessitate the property owner maintaining the pilings until they do pull a permit to replace the dock.
Okay.
Now, there are a lot of variations as to when that applies, when it does not apply, and I'm definitely not the expert in that, so you don't
Wow.
want me to provide you the information, but the situation does exist.
I know we were out on the Imperial River yesterday, and there were many, many single pilings. And we were all asking ourselves, why are they there? Now I know.
Well, I don't know if every single property owner is a land use expert and has the understanding of what they're doing, but some of them may.
or is that part of when you build the pier or dock? That's a right of use, the pilings, and you know it's your property. You want to put a dock out there. You meet the building codes and you build it. Now, when you take it out, I mean, you like them out there, so.
Right. I can tell you that in the past couple of years, I've dealt where, both Mike and I dealt situations where you had property owners asserting water title adverse to their neighbors, where you had neighbor on neighbor fighting over what could be built in the docks. And I try to avoid the city getting in the middle of those to the best of our ability.
Isn't the installation of the pilings the most expensive part of the whole thing? So why that would give them incentive to leave them if they were going to put a dock on at a later date?
Once those are in, it's pretty much simple construction after that.
Yeah, and if you were selling the property, you'd want them there for the next owner.
That's right.
So there's never reasons to leave them there.
Yeah, increase the value of the property.
That's beyond our scope, but I had a couple of questions. One was on seawalls and natural bodies on page 13. We're talking about here, which is added, new or expanded seawalls are not allowed along natural water bodies. How does that come about here? You can't put a new seawall up, basically is what it's saying, right? Let's say that you're filling in land, and to contain that land, you can't put a seawall up.
That's correct. It's not only us. Army Corps and DEP also don't like new seawalls on natural water bodies. So we regulate that, and there's criteria that says if there's seawalls on both sides of you, there's sometimes exceptions, but that's for artificial ones. So on a natural water body, you're expected to put in riprap or shore up your shoreline in some other way besides a seawall.
And the reason for that was what?
Well, what happens is the wave action comes on your seawall and washes away your neighbor's sand and dirt, because not everybody, most people on natural water bodies do not have seawalls. So mostly the wave dynamics is really
Such as, Imperial is a natural water body.
yes.
So the residential property there, those owners can't put seawalls, which I think has been a requirement for quite a while now. Is that right?
Most of it is natural. There are portions
Yeah.
of it where there's been different alterations, so that would not be considered that.
But this all came about to adopt for the city for the new law on manatees. And I think when we discussed it before, I was thinking of my neighbor down there. He's right on the river and right on my canal, so he has one set of rules for the portion of his land that faces the river, and he has another set of rules for the portion that faces
Yes.
the canal right there. And that's just kind of the way it is. I have a question, if it's time for that.
Yes.
We discussed this before in some detail, and I remember I marked here that on page 10, under G1, it talks about how to get approval for your dock and so forth and so on. And then under 1, it talks about the lot must be a buildable lot with sufficient square footage to meet city requirements, except the so forth and so on. And for some reason or another, that raised a flag because we have numerous lots in the Heitman area that are on seawalls that may not be a buildable lot.
If they were legal lots, we do have regulations in place that address those. A lot of the property that was subdivided, prior to 1960, you're looking at very small lots, and they don't meet the current minimum size requirements in some form or fashion. And so we have regulations to address if you build on those lots, what are your setbacks going to be? It's based upon the width, the age. There's several factors that go into that.
And let me also point out, docks are one of the few exceptions that as an accessory structure can get a building permit prior to the residence or the main structure being built. And that is because you want to protect this, you want to protect your water area, as well as, you want to have that built before you start construction of. So you don't want a situation, and I've had situations in the past that I've had to deal with an appeal where people want to place a dock but have no intention of ever putting in a residence. So here you do require a buildable lot, because it does, all you then have is somebody having their own fishing pier and annoying their neighbors.
Okay, on Second Street, over in Carter County in the shores, there's a series of boat lots there, maybe 6 or 8 of them, as I recall, but that can't happen under our.
New ones can. I think there's some existing already, but
I'm not sure.
I don't know.
I don't know either.
they're basically boat lots. They
Okay.
just give people a right to
I got a
vote, but
bunch
they
of
have nothing.
Yep.
No
Zits, if you,
single-
whenever you're done.
Yeah, go ahead.
Yes.
Me
dear.
again. I'm sure.
But you tell me which page-
My concern is when I do this is that somebody else is gonna read this after we pass it and go,
What were they
didn't
thinking?
anybody read that? Okay, on page 3 of 18, and it goes throughout this particular document.
Okay.
Boat ramps is 2 words, because it reads boat tramps, the way it is.
That's interesting, because we took it straight from the county, because they have boat ramp as one
Okay,
word.
and your processor, I'm sure, can find them. There's a bunch of them.
Yeah, I'll do it that way.
Starts on 3 of 18. On 4 of 18, I believe it should be in the new paragraph. It's about a third of the way down. It says, for purposes of, and it should read the Manatee Protection Plan, I believe.
Okay, where are you on
Okay,
page 4?
where it starts linear shoreline means the high water.
Oh, okay, good.
Okay, then go down almost the third.
For purposes of the manatee.
Yes,
I got it.
okay. And then I don't know if it should be again, the next one down where it says Manatee Protection Plan. Is it supposed to read the? I wasn't sure, but anyway, that would make it more
Wait, I
consistent.
have the in there.
Not-
Oh, you mean have it,
Below
the
it-
Manatee Protection Plan means
Right,
Lee County?
uh-huh.
Oh, the definition's in alphabetical
Okay.
order. I'm not going to change it.
Don, were you a English professor in a
No, unfortunately,
prior life?
it took me 3 years to get a credit in English, but I got stuck as a proofreader in one of my first jobs, so it never went away.
He's one of
That's
the
a
best-
long time ago.
And he's one of the best proofreaders on the planet. Go ahead.
Okay, 5 of 18, first paragraph. last line in that where it's Bonita Springs, include Big Hickory Pass, the southern portion of Big Carlos. After pass. 1, 2,
Wait, should I have that changed to including Big Hickory Pass?
comma, the southern
Got that
portion
part.
of Big
I'm
Pass.
just wondering if I need to change it with,
No, that's,
To
Okay.
include Big Hickory Pass.
yeah, it could be.
Yep.
Sure. Okay, we got another boat tramp in there. That's on the,
boat tramp will be a find and replace.
okay, and there's another one there.
And it's actually boa tramp, so it's a type of snake, I guess, is a trampy boa.
Very good, very good.
Thank you.
I don't understand this one here. Under submerged aquatic vegetation means fresh saline and then seagrass is stuck in there, or brackish submerged vegetation that may be used by manatees for food. I just didn't understand the seagrass part being there
I don't either.
with saline seagrass. So
I took the definition from
Okay.
Lee
Yeah.
County.
If you,
and let's see.
there are many types of submerged vegetation. I think they were just pointing out seagrasses and other, submerged
Okay.
vegetation.
So comma, seagrass rather than parenthesis,
I think so.
and then comma after seagrass.
And then I'm not sure about this one either, but let's go down 3 more paragraphs about the warm water refuge. I think it should be where manatees congregate, because aggregate's rock, isn't it?
Yeah, I think that's, I had a very bad visual just now.
Okay.
Agitate.
Yeah, well, could be. They get feisty, I guess. Page 6 of 18, down on 8, below 7-45. A fee as established in the applicable county administrative code, and it just kind of ends. Is something missing there? I wasn't sure. No, it's okay? All right,
It
fine.
sounds awkward, but
Okay.
Wait a minute, should it be county?
Yeah, well, the county's the one who actually does a lot of the permitting here, so Mike, is this one that, it should be the county fee?
Which number? I didn't catch it.
745-8.
right here,
It says county.
8.
I know. But the county does some of the processing with manatee plants and docks. It's a code.
It should be the city.
Should city be there?
Should be city.
Yeah.
Okay. All right,
Okay, and
well.
the city fee manual?
And we-
I'll put just established by the city.
Yes.
And Jackie knows the proper name for it. Okay?
I'll try to make it quicker, sorry. 7 of 18, under I at the top. I think there's a comma missing there after reconfiguration.
I think that's optional. Okay.
Geez, I may be, oh no, wait a minute. 10 of 18.
What page? Oh, 10.
If you look at, go back to 9, under minimum water depths, it says single-family docking facilities. There must be a minimum depth of 3 feet mean low water for all watercraft slips, da-da-da-da. Now, number 2 says, water depths adjacent to and within a multi-slip docking facility or a marina, period. There's no depth. Very first line.
Yeah.
It says water depth for a public service marina.
No,
I
it
think the
says no.
difference is if you go back to
Water
F,
depth, period.
F on page 9, the first part is single-family docking facilities, and it says there must be, and this is how it goes. For this one, water depths adjacent to or a multi-docking facility or marina, and then it goes, except when it's been reduced, there must be a minimum depth of 1 foot clearance.
So the E should be a small e.
Okay,
rather
so
than
there should be a
capital.
comma there.
And then the E
After
should be
marina.
small.
Okay, and a small
Actually,
E,
that
okay.
No, it should be a period.
That first sentence is the topic in which the regulation follows.
If I underline it, then it's gonna look like it's new language. I could underline it.
So,
Just it needs a small E rather than a capital E.
Well, why don't,
no.
No.
why don't you read,
It's
write it
correct.
and just call it, the other one says single-family docking facilities, call this multi-slip docking facilities or marina.
Correct.
and just leave it at that, because the whole issue is on water depth.
Okay, so delete water depths adjacent to and within a, and just have it as multi-dip,
That's what-
multi-docking facility.
Okay.
Or a marina.
Thanks.
And under G, under 2B, should that be city at the end of that? Buildable lot under city regulations?
Yes.
Take the county out of there.
Got it? Yes.
And last one, I believe. Let me see. Yep. On 13 of 18, at the very bottom, I believe we need to move the number 3 on the third line. It says determined by the local building official. Hardened structures are also subject to. Move the also into around subject instead of subject also.
Got it.
That's it.
So that's just moving the 2 words.
Yep, that's it. And, oh, and I'm sorry, there's another city that where it says county and it should be city.
Where's that?
On 17 of 18, very top. Citizens of the city. End of the first sentence.
Yes.
Where, help.
Very top, under 7-111.
Got it.
And it's also needs to be changed under 112, under where it says boats. Boat includes every description. The last line, on waters of the city.
Got it.
Okay. And I'm sorry, there's got one more. 18 of 18. Marina sanitation facilities.
A city approved this.
Well, it says marinas that provide mooring of boats.
Would be a county.
You took the 4 out. I think it should be back.
Okay.
4 live.
You're right, for liveaboard purposes.
Yeah.
Okay.
Any other questions or comments? I have one on page 11. J, we talk about marine-resistant materials or plastic for the docks. It says, except for pilings in the tidal range, wood should not be used. Would that be a marine type or ordinary wood or protected wood?
Which section again? Let me make sure.
Page
I'm on the same-
11.
Page 11,
771
J,
Y.
is that implying that you can't use non-treated wood?
That's correct.
So it should say non-treated wood,
Well,
because it talks about plastic or marine-resistant materials should be used.
you can make wood marine resistant with PVC wrap there, so it may be okay the way it is, because there's always an exception.
Okay. Also, the last question I have is on 14, where we look at the French drain, and you have 3/4 and 1 inch stone. Could that be, as long as the water, it stops the water from going over the retaining wall, such as sand, can that be used as well? Is this just a suggestion that it's gravel?
Well, it says other drainage or other drainage systems.
But when you put 3/4 1 inch stone, it implies that that is either required. That's just a suggested
approved
material.
drainage systems, yeah. There are a variety of ones, and so we put this here, yes, for an example, you know.
For example,
Yeah, so
Right.
say for example.
we review those.
Okay.
Right, and it says French drains or other drainage systems. So I think that if you have a different design that's going to work, you've just provided to us.
Well, that's right. But when I look at it, when it's written as 3/4 and 1 inch, I look at it as being that's what
Set in stone.
that
No
is,
pun
yeah.
intended. but-
stone.
Well, there you go.
That's it for me. Any other questions or comments? We have a motion.
I'll make it.
A second.
Second?
Is vote. Is there a vote need for a vote on that?
I just, as to the changes, but I don't even need a vote. I mean, I'll make them.
Okay.
It's approved.
Thanks.
This Jim.
Thank you, Meg.
The next one is Chapter 2. I did not supervise the copying of the changes, and so it looks like this, and I apologize. So you are not seeing a document that I would send out ever. Oh, they haven't got it yet? The only changes that were made since your last meeting were changes that were made as the request of Municipal Code Corporation, and the changes related to code enforcement so that we were reading consistent with state law. And when we adopt the code, it was going to be in there, so I figured it made sense to put them in here now anyway. But that was it as to, I believe, the changes since your last revision.
Mr. Chairman, before we get to this revision, or this new copy you just handed, we have looked at this before. This item D, and it seems to me as I review this one compared to the one we did a couple of months ago, I think, the only thing I see different is that it's a change in the definitions.
We added definitions, correct. That was something, but I thought your last time you reviewed it, the definitions were already included again. That was something that we are, the chapter, do you want to do the chapter 9 conversation, or you want me to do the chapter 9?
You want to do it now?
So we have, I don't know if we accepted this before with the definitions added.
I thought it was in here since the last time you saw the ordinance, because I'm pretty sure November 20th.
Because I have a copy at home that's all marked up that we discussed various issues of it, and
Right.
my note on the bottom said that they're adding adding the definitions was the main change.
That was one of the main changes. I sent out several memos that, while it did not go to the LPA for review, I sent out, I believe, some memorandums explaining what some of the changes were while I was working on the ordinance. And I want to point out that these changes, some of them, and I'll give an example of things. Both Fludra and Bert Harris talked about going to the city's hearing examiner. Well, the only hearing examiner the city uses is code enforcement. There is no way you would want a code enforcement magistrate to be doing some of those type of reviews, and that's not how the city set up its appeal procedures. So there were things that were like standard practice in the Lee County one, because we originally took this from Lee County, that did not meet our thing. So the changes, we considered these ministerial. I thought it was going to take me just a matter of weeks to make the changes. I was wrong, because there was, a lot of complication with the changes. Also, what happened is we started the annexation, and with fire district, that mean we had to change it so we had 2 fire districts in there as opposed to just 1 fire district. Another change was when Lee County changed their impact fees. The question is, do we collect 80%, or do we collect the full amount, or do we collect only 20% of like school impact fees? Because our ordinance stated something, and it was different, and EMS was another one. And there, for things where we have no control, instead of trying to put a fee schedule, I changed it so that we would only follow Lee County's. Whatever they set in effect, we'll use those numbers. So poor John's department wasn't having directional problems. So the changes were timely. There was a lot of good stuff happening to require some of these changes. There are some changes that are what I call wish lists of me. And there's also changes that I did not put in because they were too complicated. Proportionate fair share and concurrency need to be probably rewritten. The problem is I don't know what it needs to say. So I know it needs work, but I don't know how to do it. That's where a planner who can spend more time on the subject matter, and certainly more time than John or any of his department can, we can fix those issues later on. Code enforcement was interesting because it was taken out of Chapter 2. It's being reinserted in Chapter 2, and also Municipal Code Corporation is inserting it in the general code under Chapter 2. And whatever we have here will be mirrored. I put in changes that she recommended, but there is a section that I have added in this section that was not in before, and that is in the mitigation policy.
What page would that be?
I have to figure out what page myself. Starting on page 89, but the mitigation policy starts on page 93. So one of the issues that we've always had is mitigation always had to be with the property owner, and then you would have short sales. You did not have property owners, or you didn't have people who actually had title to the property who wanted to negotiate. So I wanted to make clear that we were able to negotiate and have an ability to do something, but no release of lien would be filed until that person took title. Joe Ferber is back here. He was here for historic preservation, but he can explain the process. Also added in that when determining how much of mitigation can be, the code enforcement is to consider aggravating and mitigating circumstances. Sometimes, if a property owner is dead, it's very hard for them to do work. I think we all agree on that. You're not going to get work done. So there's different times where things are aggravating, mitigating. Sometimes there's other issues. Sometimes things are aggravating because people could have fixed it. It was relatively minimal. They just kept it that way because they wanted to annoy their neighbor. And that's an aggravating circumstance. I put in language, and this is more for the auditors, that under no circumstance will a code enforcement fine be greater than the assessed value of the property. We have people getting very mad at me because I'm not going to collect $5 million on a $30,000 lot. Now, if anybody can teach me how to do that's impressive. But I don't think any judge would ever allow it. And so what it shows is that we have these great debts on our books, and yet we're not able to take care of those debts. And that was one of the things that council had a concern in their strategic meeting, because again, it shows a great debt, but it's not a real debt. And then again, the director on their own initiative, code enforcement on own initiative, can send letters out to seek additional internal mitigation to try to, get those files down. And then again, mitigation is not used as a rehearing of the original order. If you've been found in violation, you are in violation. You can't just keep going back and rewinding whether or not you should have been found guilty in the first place. But those were some changes that were added to try to make things a little, we get people, of course, concerned when they suddenly have a $200,000, $300,000. It adds up quickly, especially if you have 2 or 3 violations on land, $200,000 or $300,000, and then sometimes they just don't want to do anything. So I wanted to make sure it was something that was doable, so it could get her done.
Okay.
Are there any other changes in this package we just got other than the title page?
I think the rest of the ordinance reads pretty well as is. I don't see where it's marked up, like wrong markups.
Okay.
So I can't, again, I haven't seen, I don't know why my title block, I see there's like a whereas clause cut, kind of messed up there. But it looks like the standard language in the ordinance.
Okay.
Do you
I
have comments?
I have a couple, well, just
Okay.
a couple. Although I found this very riveting to read, I kind of stuck with the change parts.
Thank you.
Let's see. On 7 of 97, certificate of concurrency, it's almost at the bottom, second line up in the almost the middle. It assists the county. Should it not be
It's the
city again?
Where, I'm sorry.
Certificate of concurrency, under definitions. Go down to the second line up from the bottom. Submission of project data consists of this, should be city.
Thank you.
On 22 of 97, applications for development agreements. There's a comma at the end of the delete, and it should be a period.
Okay, where,
First line, no person shall have the right to apply for or receive development agreement approval. And then it doesn't, it just continues. The next one
oh, yes, thank
starts
you.
with a D,
Got it.
okay. The very next page, on 2-101, third line up from the bottom, any ambiguity with respect to, it says whether, but I think it should be what a development agreement or an ordinance is to control.
All right. I'm not, I'm trying to
Okay.
see where the question.
Third line up, any ambiguity with respect to whether a development agreement,
Paragraph,
I
I'm
think
not-
it should be what?
I'm in the right paragraph, okay. I think
That
it's
was in there
correct.
from before, so,
Yeah, because it's going to be either whether an ordinance controls or whether the development order controls.
And I think that's straight out of state statute. for
okay,
whether a-
okay. Very good. This one shows up, I'm on 41 of 97, under payment. Under B, keeps talking about in lieu of cash. Now, I'm hoping that they're not expecting somebody to show up with a bag full of money. But it reads cash in a number of places.
Right, and that's the term that's, I was not the original drafter.
Okay.
I apologize. I don't know what,
Every
right.
time I saw that, I'm thinking, yeah, that's a little odd, you know? Yeah,
Some
here's-
people may approve, yeah, but my guess is it's either a wire transfer
Okay.
or a check.
Okay.
I hope we're not receiving, although we do have audit procedures to,
And then, okay, because then on the next page at the bottom, it says certified check or cashier's check, which I thought would be, I know that adds a lot of wordage, but as long as the cash thing is understood, that's fine. Strange, but fine. 56 of 97,
I'm sorry, which page?
56 of 97.
got it?
Is that the whole section on definitions, is that not a repeat, or does it need to be there?
This is another thing that needs to be fixed, and we have two different types of park impact fees. We have regional park impact fees for the larger, and then we have community park impact fees. So when you build a residence, you pay two different types of fees, and we have two different things. We should merge them together, but that would take another impact fee study. and
Okay, it just looked like it was, we're
There's
doing
some
it again.
redundancy.
Here's my cash thing again on the next page. Okay, we'll let that go. On 64 of 97, definitions again. Do we really need to define what the fire department does? I don't know, I mean, fire protection means the prevention and extinguishment of fires. Really? That's a surprise, I guess, but it just, I don't know. If it needs to be there, that's fine. It just looked like it was something that was,
But it also includes, fire protection includes rescue.
yes, it
So if
does.
they were spending money, let's say a fire department wanted to spend money on their fire impact fees, and they weren't spending it on fire protection, say suppression stuff, but they were spending it on rescue stuff, I think, there would be an argument if you did not have it in there.
Okay.
Could somebody say you're inappropriately spending fees? I'm actually working on an email right now on roundabouts and whether or not that improves traffic capacity because it's displacing a red light. How's that for a education moment?
Those are a lot of fun, especially with a motorhome.
I hope they're not planning more
Very
than
entertaining.
41.
But you get through faster than a red light, hopefully.
I don't find anything else on that one.
Yay.
For a big document. that's
Yeah,
not bad.
that's, yes, it is. It's
Mr.
very good.
Chairman,
Yes.
I have a question for Audrey. On page 19, we're talking about concurrency management, but essentially, that's the theme of this ordinance here. And we have established a date of November 2 of 2002, and it brings to question to me vested interests. And I remember back when we were first starting this LPA years ago, the land attorney for, I think it was Westinghouse back in those days, came with a letter which established a vested interest for 9 towers out there, and it really was nothing. But yet it established a vested interest. So I'm wondering, can we just arbitrarily change a date from 1990 to 2002 and wipe out anybody's vested interest?
It's not actually an arbitrary change. It's a change to when we actually created a comprehensive plan. And what this is saying that we're keeping the inventory as of when our comprehensive plan began, as opposed to the the county's change. Now, understand concurrency was, comprehensive planning started prior, the Growth Management Act preceded concurrency management. Concurrency management, the law adopted was either late 80s, but the county started theirs in 1990. So you did not have concurrency concepts until 1990. You had a growth management, you had the planning aspects, but you did not have a concurrency plan in place until 1990. This is just saying that the inventory that we're keeping is based on our comprehensive plan. Will we still give vested rights? Absolutely.
Maybe I didn't ask the right question exactly, but that's kind of the key here is the vested rights that that were in place, for example, in October 1st of 1900, even though we weren't in existence. There, when we became in existence, we accepted vested rights for
That's-
people before we
still
were
will.
there.
Your question's a little bit different than what's shown here. Your question is not necessarily addressed by this. This change simply removes the county's date that they established their concurrency and replaces it with the date that the city established its concurrency. So we didn't establish our concurrency in 1990. So having it in there is not correct. Changing it to 2002 shows the date that we established the city's concurrency. In terms of vested rights, this does not change our position on that or have any impact upon that. It just corrects a date.
Okay.
That didn't make it any better, did it?
All right.
Any other
The
questions, comments?
Right. The date, concurrency is a very strange concept, and at this point, concurrency has been obliterated by the state of Florida. And and by that I mean it says you no longer have to follow concurrency, you can get rid of it. We are not ready to make that recommendation. I mean,
You have
when
to
you're-
replace it.
When you're ready to, yes, and you replace it with proportionate fair share, there's other tools in the shed. Concurrency is an outdated tool, I guess, is a good way to.
Yes.
The question is, do you want to get rid of it when it still is expensive, it works nice, you want to keep it for some elements? At this point, we don't want to do a lot of changes, but what we do want on concurrency, one of the few changes I made was recognizing that we didn't keep inventory in 1990 because we weren't here. We started in 2002. But it doesn't mean that, for this particular use, it's the inventory system. We would go back to the county if we needed to go back to the county for any information.
So it's
on
applicable.
But this is concurrency showing whether the road was a level C, a level D, what was the road level. And with the amount of improvements, most of the ones that were really failing, fortunately, are no longer failing, I hope.
Other comments, questions?
And you have the comment I made on page 89 about, I think it was 89. Yes, about changing the article number.
Yes, thank you. We had I went up an extra article.
There's no article, I guess there was no Article 11. This one was 12, so now it's 11.
Okay.
Yes.
Are you ready for
Okay.
Missed that, Don.
I don't know, we have another proofreader, that's a good thing.
We have a motion on the, this ordinance.
I make a motion and it complies with the
Second?
I'll second it.
Second's been had. Approved. I don't think there's a vote necessary on this one as well.
Okay.
That's a
Move to
monster.
the last one, I guess.
And it's not mine. Yay. Yeah, plus any copies of any changes. I don't make a copy.
Good morning. For the record, Joseph Ferber, Assistant City Attorney. This is an ordinance restating and amending Bonita Springs Ordinance Number 09-02, amending Chapter 5 of the Land Development Code relating to the Historic Preservation Board, providing a definition for Florida Master Site File, discontinuing financial disclosure filing requirements with state for Historic Preservation Board members, providing for appeals pursuant to LDC Section 4-83, providing for administrative approval on requests for regular certificates of appropriateness, providing for posting as method for notice of public hearing on requests for a special certificate of appropriateness, providing for exterior colors for designated historic resources within the old 41 overlay, providing for conflicts of law, severability, codification, Scrivener's errors, inclusion in code, and an effective date. These changes are actually very few changes were made to the ordinance as recommended by the members of the Historic Preservation Board. I can summarize them for you if you'd like. Of course, they're underlined in the context of the ordinance. I can summarize them. Section 5-3 simply was amended to add definitions for the Florida Master Site File and expanded the definitions for the Historic Resource Database and staff. Section 5-42 revised the appeals procedure to be consistent with Section 4-83 of the Land Development Code. Section 5-72 deleted the financial disclosure requirements with the state for Historic Preservation Board members. Section 5-73 omitted the necessity for the city attorney's presence at meetings where the board is not discussing matters impacting individual property rights. Section 5-102 provides for administrative approval on requests for regular certificates of appropriateness. And Section 5-103 provides for posting as the method for notice to public hearing on requests for special certificates of appropriateness. And lastly, Section 5-241 provides that changes in exterior colors to designated properties within the old 41 redevelopment overlay shall conform to LDC 4-1154 C5, which, as you may recall, is the color palette. I'm sure Chairman Vincent's very familiar with that. And that's basically it. I'll be happy to answer any questions.
I have a few. This document seems to have, there's a lot of power being handed over in this thing. A lot. And some of it concerns me. On page 4 of 29 on the bottom, the last paragraph, special certificate of appropriateness means a certificate of appropriateness issued directly by the Historical Preservation Board. That seems to be putting a lot of juice in somebody's hands that's not been elected.
Well, understand that regular certificates of appropriateness basically relate to just maintenance issues and nothing of a structural nature, which would require a special certificate of appropriateness, and that's a whole different procedure. So up till now, the Historic Preservation Board has approved these regular certificates of appropriateness. The proposal under the amended ordinance would be that these could be handled administratively.
Okay. On 9 of 29, it lists the categories of that these members should be from. Have we done that? We have these, the board is sitting now, is that correct?
Yes.
And we have someone from each of these categories?
I can't guarantee at the moment that we have someone from each of these categories, but we have several of the categories represented.
Okay. Okay, well, I had another question on 10 of 29, but that was number 6, but you said they've been doing it as we've went along, so okay. On 11 of 29, number 15, upon designation as a certified local government?
which we are.
Is that, it seemed to me that that was referring to the Preservation Board.
No,
Refers to the city.
it refers to the city,
Okay.
and it's that the city is designated by the state of Florida for its historic preservation.
Okay,
We are, City of Bonita Springs is what's called a CLG city.
right, but I just wanted.
Certified local
It
government.
looked like it was being grouped in with the Preservation Board. Okay. I think that was my last-
Originally, this board was the historical
Right,
board.
exactly. Okay, I think those are my only questions.
Chairman, I have a question for Joe. That I'm looking at, say, the top of 13, but my question involves a situation. Just recently, in the last year or two, there's been some heavy revisions in the insurance industry, and people are getting cancellations on properties. And one of the things that I have found, I have a building that was constructed in 1981, and my insurance company notified me that I had to change the windows to the storm-resistant windows, or they would not renew my policy. Or that was going to be one of the deciding factors. Putting up shutters didn't count. It has to be, nowadays, I guess it has to be the storm windows. So ultimately, that's going to bring a conflict into the historical preservation area of, as far as appearance of these buildings, because these new windows are a substantial change from the existing windows.
Rex, if I could?
It's,
We have family up in Connecticut, and in one little town, especially in Glastonbury, they are dead sticklers for, if you have a house that's got that designation, whatever you do to it, it better look the same. And my wife's cousins have done very well in manufacturing, and they did it out of aluminum. I don't know how he did it, but he made all the exterior crown moldings out of aluminum. And they also manufacture impact-resistant windows that mimic the old stuff. I mean, you have to get right up to it, and that was their criteria. You couldn't tell from the sidewalk that anything had been done to these buildings. It's not cheap by any stretch of the imagination, but it's doable.
I see. That's interesting.
It's
Because
doable.
it is an issue that
Uh-huh.
is being raised. We went through the roof nailing and all that sort of thing, and the gable end restructuring and so forth, but those things are not visible.
Right.
But when you're dealing with a historical situation, my building's not historical yet, 30-some years old, but when you're dealing with this, and to preserve the look requires some pretty extensive.
Oh, yeah. Yeah, and most of the windows are vinyl.
there's a certain level that you'd want to achieve, though, with that. If you're changing use and you're not remodeling, if you will, to the exact requirements of the age structure, then I believe, if I can ask John a question here.
Yes, sir.
I believe recently building official is not requiring that impact-rated windows be applied to work on historic homes. Historic in the sense that the city's approved it as historic, not national.
Yeah, I think that what he's looking for is them to meet the standards of the building code. And the building code, I believe, allows them that option of shutters or impact-resistant glass. However, if you want to go down the replacement of those windows, Mr. Calapietro, you were exactly right. It used to be that impact-resistant glass was impact-resistant glass. You knew what it was. It was very easily identified.
Mm-hmm.
That has changed considerably. What people are able to do now with replacement windows, shutters, any type of housing rehab, you can make it look almost identical to what it was prior to the refurbishment. So when you're looking at a concern of if windows are replaced, are they going to look original? They can. That is a definite possibility. It does cost. It is not the same price as putting in standard impact-resistant glass like you'd see in a new construction home. However, it is accessible and it is doable.
Okay.
John, further in that, Rex, I believe I mentioned different levels of repair, and I can't remember the names. Do you recall, John? The distinguish between, or you, Joe, replacing to mimic the original product, or this is just a repair. You know, in historic structures, you don't have to copy what was originally there.
Yes, we have. There has not been a lot of rehab of older homes since 2008. So what we've been able to do is work with owners. They have provided us evidence of what the houses look like, or the commercial buildings looked like during some portion of its history, preferably towards the earlier part as opposed to the later part, and we've worked with them to bring it to that condition for any repairs or remodeling that they've done.
Right. I believe reconstruction is one of the terms I was looking for,
Yes, sir.
that you would use.
Oh, I'm sorry. Yes.
If you were looking to reconstruct, that means one thing, but if you're doing something less than that.
You're right. They've broken it down into levels, and it has different standards for
Right.
each.
I don't know how that would apply to you, Rex, with your insurance company here, but that may be a totally different issue than historic homes.
And what we try to do, because there are competing interests. I mean, what type of products are available for your type of remodel? How much do they
Right.
cost? What are the insurance requirements? We try to balance those concerns. If it's an item that needs to go to the Historic Preservation Board, to give them a recommendation that tries to meet everyone's needs. You don't want to allow someone to rehab their house only to turn around and have it be uninsurable.
Right.
So
I know that the residential building code discusses level 1, 2, and 3, and you're supposed to define what it is you're doing so the building official can apply the rules correctly.
yes, sir.
Yeah.
That's
So I
exactly
think
right.
that's covered. Any further discussion on this ordinance? Let's see if I have anything else here. I think what we're saying here under section 5241 with the exterior colors of designated on page 26 of a designated historic resource shall conform to the provisions of LDC, et cetera, shall be reviewed and approved by the city's architect. So that allowance, it will allow you to, the city's architect to decide whether or not you need to comply with the color palette, or to choose to go with the original colors of the house, of a historic house. In other words, historic houses typically will have 2 or 3 different colors. When you get down to the bottom layer, it may be totally different than, and may be pretty obtuse when considering the color palette for the city. And so the confusion for me here is choosing, I guess, is it a reconstruction, or if it's something else? If it's something else, can a color be approved based on the level of the reconstruction?
I think that issue has recently come up with regard to the bungalows at the Lyles Hotel.
Yeah.
Because there was, as I recall, there was some history pertaining to various colors that were initially used at
Symbolic,
the
I
bungalows,
guess.
with stripes and things like that.
Correct.
And then it was determined, the city council determined that the color palette should be applicable to that area. And it was, I believe, your determination that the
Yep.
colors that were on the bungalows were not in conformity with that color palette, and as a result, the city changed the colors to the bungalows.
Thank you, Joe.
For this ordinance, what would make you feel more comfortable? Did you want something that would kind of push it along in one direction or another, or?
Well, that's what I was taking some time over, is whether or not,
Because from my perspective, I'm okay with having the choice, because I think there are certain situations that either side of that coin would be a better option. But it still leaves a choice, and if you're looking for something more definitive,
the only thing that would be definitive, I think, is if if you're looking at a pure reconstruction. In other words, the owners of the property, say the Historical Society, is saying that we want to replace parts and pieces to this building to match the original exactly. In that particular case, you may want to choose the original color to remain true to the original construction and the thought process of the owners at the time. Whereas if you're not doing it for that purpose and you're meeting some other needs, then the color palette for the city would apply, is what I'm... Joe, is that...
I think the change clearly states that this shall be reviewed and approved by the city's architect in accordance with any designated color palette adopted by city council. So the ultimate determination for the color palette would be by city council, and it would be incumbent upon the city architect to apply that standard. So I think the question is really answered.
Yeah, I accept it as is. Is there a motion for this?
I'll make a motion to find that this ordinance is consistent with the comp plan.
A second?
I'll second it.
Motion is passed.
Thank you.
Thank you, Joe.
Just one last thing, and that is I want to introduce Justin Diner. Justin will be in our office for about 6 months. He will be a staff attorney. He's not an intern. He is a graduate of University of Florida for his undergraduate and University of Miami for his law school. He is admitted to the Florida bar. He will be learning about local government and land use during this time. And if you have questions, I'm able to use him as a full attorney, so I'm very looking forward to his services. But if the LPA has any questions of him, feel free to do so.
Did you say University of Florida?
Yes, for his undergrad, which is a mighty fine school, just like LSU, sir.
Acceptable.
Except in football currently, but this year.
Welcome aboard. Okay. Public comments. If there are any, please step forward.
Take a number.
Yeah, there doesn't seem to be any, so let's establish the next meeting is Thursday, January the 9th. Any objections to that or changes?
I think that works.
If
No
not,
problem.
January 9th will be the date of the next meeting. And call for an adjournment. Thank you very much. Happy holidays. Thank you, Joe.
Oh, yeah, that's nice.
Does anybody